Okay, we'll go ahead and get started. Hi, everyone. Thanks for joining our Guide to Commercial and Technology Contracts webinar. I'm Cory Helton. I'm a commercial and transactional attorney at KO Law. We've got KO partners Dan Fredrickson and Matt McKinney joining us. I'm going to share a few housekeeping items, and then we'll get started. So first, just a legal disclaimer. Today, we'll be discussing general best practices, not specific legal advice. Facts and circumstances are different for every business and in every situation. We recommend working directly with an advisor to handle your specific circumstances. Today's session will be recorded and shared after as well. CLE credit is pending, and we will follow up with the course ID if it is approved. For Q&A, we'll answer questions at the end of the webinar. You can submit questions using the Q&A button at the bottom of your screen. If we don't get to your question live, we'll share contact information at the end so that you can follow up. So as I mentioned, I'm Cory Helton. I'm a tech and commercial transactions attorney, and I've been with KO for 7 years. I'll be serving as your moderator for the webinar today. Matt and Dan, can you please introduce yourselves before we get started?
Yeah, absolutely. Hey, everyone. Dan Fredrickson. I am a partner at KO Law. I've been here for almost 11 years now, and my practice really focuses on commercial and technology contracts. I work with companies of all shapes and sizes on their technology contracting needs, representing everyone from early stage startup to mature and established businesses. Happy to be here and happy to get into the weeds on some of this. Over to you, Matt.
Thanks, Dan. Good morning, everyone. Thanks for joining us. My name is Matt McKinney. I've been practicing overall 22 years, about 11 years here at KO. Fun KO trivia fact, Dan and I started on the same day. So if you're ever playing bingo or legal nerd Trivial Pursuit, that might be your answer. My bio is almost verbatim what Dan just said. I'm a tech commercial lawyer, do a lot of work with SaaS software, data services, professional services organizations of all sizes and places on the company growth maturity scale, multiple industries, yeah, look forward to chatting and having the conversation. Cory, I will talk a little bit about the firm and then hand it back to you. So KO is a specialty transactional corporate boutique. We have 3 main practice areas: a corporate transactional group that does essentially cradle to sale representation of organizations. So everything from entity formation through the life cycle, any debt or equity financings, any board level work, and M&A in between. The group where the 3 of us sit is our commercial technology and operations contract group. We do more of the day-to-day work. So everything from basic non-disclosure agreements up to very sophisticated bespoke joint development agreements and everything in between. So here we can handle basic employment agreements, commercial leasing, and then I'd say our bread and butter are kind of the contracts companies use to either procure or commercialize a technology, a service, a product, or intellectual property. And then our third group is our data security and data privacy group, where we have a handful of experts who are tracking and advising on the regulatory landscape that is ever-changing domestically and internationally for the collection and processing of data. Cory, I will turn it back to you.
Great. Thanks, Matt. Thanks, Dan. So just as a general overview of the topics that we'll cover today, first, laying the foundation for contract negotiation. Second, navigating common contractual issues and risks. Then we'll move on to best practices for contracts management. And finally, how to accelerate contracting and sales. Just a quick note for the audience, while we'll be discussing these issues from various vantage points, most of our discussion will be primarily from the viewpoint of the vendor. Okay, well, kicking us off, so Matt, let's start with you. Let's say that I'm a client and I'm ready to start selling my product, start providing my service. What should I be doing to prepare for that? And what should I be thinking of as I'm getting ready to kind of go to market and start selling?
Yeah, I talk to my clients about kind of a 2-step process. One, assuming budget allows and time allows, I think clients are very well served by going through the exercise of creating a form agreement. And this is sort of universal, whether we're selling a consulting or professional services or a SaaS offering or on-prem software. To me, it doesn't really matter. I think the actual process and exercise of thinking through, all right, what is our offering? How are we going to be compensated for it? What are the constituent parts? Like, what does the finance and accounting team need to weigh in on in terms of payment or revenue recognition? What can our product team commit to in terms of representations and warranties or maybe service level agreements? We might have a privacy group that needs to speak to what the contract can say about our security practices. And of course, legal and management and everybody else may have a voice in there. But I think that exercise of helping a company think through what this contract is really representing, because as much as the three of us might think we're doing something special with these contracts we're putting together, I think we'd all agree that the vast majority of them are commercial and business terms that we are packaging, hopefully in readable, sensible, plain English, and putting out to the world to help get deals done. So I would start there, especially with young early stage companies. And I know that what I just said can be a little bit of a tension or a pain point where a young company may not want to be spending time and money with their lawyers. But I think an ounce of prevention is worth a lot of pain down the road. I also view a form contract in this exercise as being educational for the lawyers, whether it's in-house or outside counsel like us. It helps give us a better view of what's going on in the company. What are we really selling? What is the value proposition we're taking out to the market? So I think there can be a long tail of the benefits from this exercise. The contract is really embodying the operational realities of the company, the risk tolerance. I think we all probably have clients that are exceptionally risk tolerant, and clients on the other end of the spectrum who want as little risk as humanly possible. And going through this creation of a form agreement helps us, and frankly helps everybody understand kind of where we're trying to place this contract on the risk spectrum. So that's my general thought. Let's start with a form agreement. Let's get something that represents the business and use that exercise to bring everybody together so we all know how we're all interacting on this contract. I just want to pause. Cory, Dan, any other thoughts or ideas on the notion of starting there? Let's have a foundational agreement and do this exercise. Do you see that working with your clients?
Yeah, absolutely. I agree with everything you just said. One additional point, I work with a lot of clients that almost never are able to use their own form when negotiating with customers, especially large enterprise customers that are going to, insist on their own contracts. Even in those instances, having that initial form serves as a really wonderful playbook, right? To really put a stake in the ground to at least establish where the company's preferred positions are going to be, and what it might look like when you deviate from those. So yes, I completely agree with having a form. Going through the process really helps you to get your thoughts in order to be able to start contracting.
Good.
Really hit the ground running when those red lines come, or those customer contracts come, because knowing those answers on the front end to the extent you can seems to kind of alleviate the back and forth of having to, hey, have you talked to your tech team? Have you talked to your security team? Can we do this? Can we do that? So I think it's a valuable exercise.
Great. So once we have that in place, we're going to market, we're starting to sell. Then what? So now, we sort of started here at the 60,000 foot level. Let's put together a form agreement and do that exercise. Now we've got a particular customer that we want to sell to. Now that I'm there, or we're there, now I'm looking at the context of the deal. I'm trying to work with my client, whether it's the sales team or the finance team. Our touch points can be different points in our clients. But, tell me about the deal. Like, I think we, as outside counsel in particular, but I think this is true for inside counsel, like, we provide more value when we have the complete picture of what's going on. Maybe it's an inconsequential deal in the middle of the quarter that has no real bearing on revenue or higher level concerns within the company, and we could take it or leave it. But oftentimes the customers, the clients we're working on and the deals we're working on are important. It's either a quarter end deal or a year end deal or a key strategic partnership or a logo we want to get on the website. And so just understanding what the drivers are, I think helps us understand, how much leverage we have, how much we can push, where we want to focus our efforts. So I always encourage clients, when they're thinking about the relationship with their lawyer to provide that context. I also think that there's an element of that is outward looking too. I encourage my clients to really try to be proactive in their sales process with educating their contact at the potential customer, whether that's procurement, sometimes it's legal, maybe it's the business owner, educate them, make sure they understand what they're buying, what they're paying for, not the intricacies of the architecture of the technology necessarily, but what is it processing? Is it multi-tenant SaaS? Is there an on-prem component? What data do we need to provide our service? And I'm speaking very generally here, trying to just capture different concepts from different types of companies. But I think this will come up a little bit later in our talk, that educational piece, that getting the customer on board with what we're actually doing and how we're fitting into the customer's bigger picture can help speed the contracting process, knock down some walls, just make it a little bit smoother. And I guess just to go a little bit deeper, I like to think through it. If I'm the customer or representing the customer, I'm going to want to think through things like, is this a mission critical service? Like, what happens to my business? What happens to my revenue generation if Dan's SaaS service goes down? How am I impacted? Maybe there's no impact. Maybe it's critical and revenue stops. You could see that with an ERP system or some sort of POS system. And that is going to change how I advise. That's going to change how I think about the structure and how we're going to protect our client. So that contextualization of what's happening, or how the deal fits into my client's overall picture, I think is important. And from there we can get into the weeds. We can start talking about, okay, what do we need for a term? If we're the vendor, we generally like longer terms and automatic renewals and some sense of locking that customer in. That's probably not the term most people would use, but a more concrete period of time to get a higher probability of that revenue coming in.
Mutual commitment.
Mutual commitment. There we go. And obviously on the customer side, they may want termination for convenience. They may want a month to month. They might only commit to a 1 year with no auto renewal. So, I think as you think about that context and what we need as the vendor, what we need as the customer, that's where we start getting into the weeds a little bit of the component parts of these contracts that we're talking about. Let me pause there. Dan and Cory, I went off again. What do you have to say, or what are your thoughts on kind of this going to market step for presumably a younger company who's doing this for the first time, or maybe with a new product?
Yeah. I second everything you just said. I also think it can be particularly helpful on the selling side, on the vendor side, to really keep in mind that at this point, everyone wants to do a deal, right? And so there are opportunities to invite collaboration for these types of arrangements, right? It's not necessarily us versus them, vendor versus customer, right? So when you start thinking through these issues and you are able to develop a full understanding of what you as the vendor or what you as the customer need, whether it's resiliency because it's a mission critical product, or a longer term commitment because that's how you price the deal. Being able to communicate that in an effective way allows you to invite collaboration to say, this is what we need, or this is what we're trying to solve for. How can we get there? I think that helps to, really draw a line through all of these other issues that we're going to be coming up against.
Yeah.
Yeah. Never losing sight of the forest through the trees.
That's right.
Yeah. So Matt, that was super helpful. And Dan, now that Matt has highlighted some of the steps that vendors can take as they're preparing, getting ready to put their best foot forward. Likewise for customers. What are some of the areas where folks can reduce risk and contracting friction as they're going through these negotiations? So we're starting to identify these points, and now to what you just mentioned, how we kind of work through those in ways that are mutually beneficial.
Yeah, no, it's an interesting question. Risk and contracting friction often go hand in hand, right? The effort to shift risk is frequently what leads us to some of these challenging contracting issues, right? Whether it's indemnity or limitation of liability or what have you. I think some of the most important things that companies can do as they're getting to this stage, and in an effort to eliminate friction, is to fully understand their own pain points, right? And there's a big distinction between a walkaway item, right? Things that we absolutely cannot accept in a contract versus things that are nice to have, even if they're really important to have. If they're not walkaway items, you're going to treat them a little bit differently, right? So, for example, intellectual property, for most of the companies that I work with, intellectual property is a walkaway item, right? We need to make sure that our ownership of baseline background intellectual property is clear as day, and we are not compromising in that. If that is a point that is causing friction in the deal, to me, that's an indication that we haven't done a great job of educating the customer about what it is that we're offering. And so it's an opportunity to say, hold on, let's make sure we're aligned, right? And problem solve there. Again, inviting that collaboration, inviting our sales teams back into that process, again, making sure that we're all aligned there. That's a completely different approach, I'd say, than the nice to have items, where we're going to push really hard to have a long 5-year auto renewing term of the agreement. But at the end of the day, if we really need the revenue and we're going to take it, we're going to approach that kind of differently. So again, point one then is knowing those walkaway items, right? Raising them early, understanding your pain points, and then again, having a very clear grasp of your own technology and what you need to be able to offer it. In this day and age, data sovereignty comes up all the time, right? Especially when you're contracting with large enterprise customer. It's frequent that you're going to see a provision that says all data needs to reside in the United States and can't be accessed from outside the United States. Well, if you maintain an international team, whether they're doing development work or they're doing customer service or whatever it may be, and data has to be accessed from outside the country in order to provide your service, you're going to need to get in front of that pretty quick so that you can explain to the customer, this is why we need this change. And then invite the collaboration of, we understand your pain points, customer. How can we best address both of these things in a mutually satisfactory way? So yeah, that's some of my initial thoughts on that. I'll pause. Matt, Cory, anything you'd add?
Your point on intellectual property, like I have one example that has come up repeatedly that I'll just throw out there as an example, and that's like viewing IP through the lens of a professional services engagement. Now, whether that's a client that is just professional services, or maybe they're doing implementation for their SaaS or software offering, I see the biggest stumbles with IP ownership or licensing in that context, where you've got a provider that has some body of pre-existing or background intellectual property or know-how. They bring it to the table. They're doing some custom work, some net new development. And the idea might be that, vendor retains ownership of the background IP, but will transfer ownership of the net new IP to the customer. That we almost always get through it. But to your point about being clear up front and educating and explaining, hey, this is how we offer our professional services. We have some, the reason we were able to provide you great services is because we have 15 years worth of experience and a body of tools that we bring to every engagement. And you're not going to own those. You can have a license to those. Here's what you own, and drawing those lines and, being able to explain to that customer, this is why it has to be. And if you expect something else, this probably isn't the right fit for you. Because that vendor requires retaining that intellectual property.
Yeah.
And I was just going to throw out generative AI. We may hit on that a couple other times, but I was going to use that as an example of kind of getting ahead of some of these potential deal friction points. I've seen this both representing vendors and representing customers. Just it's a buzzword. Some people understand it, some people don't. But to the extent you're a vendor and you are incorporating or using or basing your platform on some element of generative AI, whether it's homegrown or you're using OpenAI or some other commercially available platform, just being aware that it is a touchy subject. Customers are increasingly worried and concerned about their data being used for training or being used in a third-party generative AI platform. So, if we're talking about both reducing risk and friction, getting ahead of generative AI use, I think is sound advice, and not trying to hide the ball.
Yeah.
As people get more sophisticated and educated.
Yeah, absolutely. And in some ways, just thinking through what are your customers' expectations based on your specific service,
Yeah.
right? And who the customer is, right? We can anticipate customers that are going to be particularly sensitive about certain issues, right? Whether it's generative AI or, data privacy or you name it, right? And so thinking through ways to present the issues in a way that addresses the customer's concern or the customer's expectation is going to be valuable from day one. So to your point, generative AI, addressing it up front, ideally during the sales process, right? Explaining not as a bad thing, but as a good thing. We leverage generative AI so that we can provide our services in a more cost-effective way, right? Right? Or presenting a customer with a data protection addendum to your agreement that says, yeah, we do collect data, personal data, and we understand that it's sensitive. Look at all the things that we're going to proactively present and say, this is how we're going to protect your data. Or we provide the mission critical software. Look at our SLAs that we offer on day one. You don't even have to ask for it in the negotiations, right? Putting those things in front of the customer in advance not only can reassure the customer and the whatever procurement team you might be working with, but it also helps to avoid a situation where the customer says, oh, you don't have an SLA or a data protection addendum, or you name it. Here are our standard terms that now we want you to agree to, which just adds to more contracting cycles and more negotiation difficulties.
Yeah, and it all just circles back to that initial exercise of understanding your contract, getting that form together. We can anticipate the questions that are going to come based on, are you storing data offshore? Are you using generative AI, and putting that best foot forward for your customers to show that you know what you are doing, and you've thought through this, and you can provide a commercially reasonable solution to them. I think can go a long way, because filling that vacuum of silence is not always fun when it's coming from procurement, from a business perspective. So that was great. Thanks so much. So Matt, I want to circle back to you. Discussing common contractual issues and risk mitigation strategies. We're talking about these things that are going to come up, and so segueing in to potential solutions. Can you speak to what you do during the negotiation process to kind of get these mutually beneficial solutions?
Yeah, absolutely. I think there are kind of two lenses, maybe a primary lens and a secondary lens that I use, in the heat of the negotiation, right? Trying to get a particular deal done now. And the bigger lens, and the more short-term lens is, all right, let's look at the risks through this short-term lens of getting this deal done. Like, what are the risks to us for this deal, whether I'm vendor, whether I'm customer, right now? The second lens isn't going to apply to everybody, but many of our clients are on the emerging fast growth track, or startup-y track, whatever term phrase you want to use. And many of them have aspirations or hopes for some flavor of exit, whether that be strategic acquisition or private equity, or some IPO. So I think maybe not on every contract everybody does in companies that fit that profile, but many of the bigger contracts should be viewed through that bigger lens of, okay, someday we're hoping to undergo a transaction, maybe even an interim financing or a major investment along the way. That means for that subset of clients, there is this other lens. Like, let's make sure this contract, this particular deal, kind of falls within the norms, a standard deviation of what a sophisticated buyer or sophisticated investor would consider to be normal. So I don't know if it's quite the 80-20 rule, but I'm probably spending 80% of my time thinking through okay, short term. Let's just think about this negotiation and this contract through getting the deal done, in kind of, to Dan's point, like, how do we get to yes? How do we get rid of the non-negotiables, or identify them and get them out of the way? And then let's find the path towards a mutual understanding and mutual agreement. While also just being conscious that this contract might be, again, an important brand, high enough dollar value, have a strategic value that's going to be important in a broader context of mergers and acquisitions down the road. So that's where I'll start, just kind of through that framing. This is probably a gross oversimplification, but if we're in that 80%, like, let's just get this deal done, what are we looking at? If I'm talking to my vendor clients, start with the easy stuff. Well, like, what's the contract say about us getting paid? When are we getting paid? Is it in advance? Is it in arrears? Is it quarterly? Is it monthly? Let's make sure that cadence lines up with what we need if the customers propose something different. Do I have some rights if I don't get paid, right? Can I suspend? Can I terminate? Let's make sure I'm protected from malfeasance. Well, it doesn't even have to be malfeasance, from a intentional or unintentional bad act by the customer. And then kind of the big picture, like, is the overall risk allocation reasonable and acceptable and going to be something I can pass up the line to management and them say, yeah, this is fair risk given the deal and the dollar size and the benefits for us. And within, there's a ton to unpack there and probably 3 more webinars on all the nuance of liability and indemnities and limitations of liability. And I just don't think we have enough time to go into that, but that's where I'm thinking about those concepts, caps on liabilities, disclaimers. Dan, you touched on data processing a bit. That's a huge one in this day and age from both customer and vendor side. Like, what does that look like? Like, is it accurate? If we're the vendor, that's where we're going to really want to be able to present our DPA, our security standards, because that represents our operational realities. If I flip hats and start thinking through the customer's lens, what are my expectations? Does this contract actually say the vendor is going to perform to a particular standard that meets my needs? So we're talking about warranties and maybe just operational obligations. Maybe that's service level agreements. And I think from the customer's perspective, the biggest question is what happens if it doesn't work, right? There are services that just have zero impact. They're nice to haves. They're a bell or a whistle. But if the vendor disappears tomorrow, it's not going to have any material impact. And then there are obviously services that are mission critical. And we touched on some earlier, ERPs and POSs and the data warehouse, right? That your day-to-day operations might be dependent on. So how do we get sort of redundancies and protections that are going to give us as the customer some comfort that we're going to be okay? And the last big item that on the customer side that I think about, especially in a hosted service or a data service, is what does that transition look like? If the agreement hits its natural expiration or there's an early termination, is this the type of vendor relationship where this service is so robust and so embedded that I need an additional 6 months just to transition out from that vendor to my new vendor? And that covers everything from, actually having the service there and the features and the functionality to the data. Like, how do I get my data out? Is that easy? Is it complicated? Is it going to come in a format I can easily reuse? So I think those are, kind of that top level set of issues and questions that I would go through depending on what my client's role is in a particular negotiation, to kind of think through, or at least to set the stage for that framework of, all right, where are we allocating this risk and what is appropriate? Well, inappropriate's a terribly subjective concept, right? Like, it's going to be deal specific. One last thought on this kind of allocation of risk notion. I remember the first time, probably, I don't know, a decade ago, doing a deal with a large household name, like hosting provider, one of the early ones. And my client had zero leverage. And the approach from our friends on the other side, when we were asking for some protections on data security, was, hey, this is shared risk. We are in this world of shared risk when it comes to data. We're telling you what we do to secure our platform. You're going to host your data in your software here. You control some of that risk by what you put into our hosting environment. And it was the first of many times I have sort of run into this notion of a vendor saying, hey, it's not like we are not the insurance company. You don't get to shift all the risk to us. It is this shared notion. And you, customer, have a say in how you configure my service, what data you put into my service, how you use it, who you give access to. So I'm sharing that as an example of a theme that I think is becoming pretty embedded, at least in hosted services, that acknowledges these are complicated systems, and customers really do. Despite my early resistance to this logic, I do think customers have a role in understanding what they're buying and how they have a role in the security landscape, for example. or the generative AI landscape maybe. So I just throw that out there as something to consider in any negotiation, like whether you're vendor or customer. Is this a shared risk type of conversation, or is it not? In my one example of not might be intellectual property infringement indemnity. I think it's still true that that is a risk that the market still says should be borne by the vendor of the technology. But after that, like, it gets a little more gray. So again, I feel like I had the microphone too long. Danny.
No,
No,
I just want to touch on one other point. I liked your framing of the two lenses, right? And it's really interesting from a risk perspective. When we think about contract risks, we're often thinking about liability, right? What happens if you breach, right? How much money are you going to have to pay? Or what happens, right? But through that second lens, right, the lens of what happens in the future with a prospective investor, prospective acquirer, right? There is risk there too, and it's not risk of breach, but it's deal risk, right? Setting the stage in any kind of large corporate transaction where someone is buying a piece of your company, whether through an investment or full scale acquisition. You're going to have lawyers like the three of us sitting in a room pouring through all of these contracts and trying to identify any areas of concern. And so there are times where I've told clients, look, from a legal perspective, this provision is probably fine, but it's weird. And it's going to be an issue in a potential investment or an acquisition, right? Someone is going to see it, and it's something that you're going to have to talk through. If it's a really big deal, representing a lot of revenue, maybe it's worth it, right? If it is just, run of the mill new one contract of 100, maybe you're not going to take the risk that you're going to have diligence calls on this one particular topic. So kind of having that in the back of your mind, especially if you're one of these, a venture company of some sort, is particularly worthwhile.
Dan, maybe it's worth digging into that a little bit more. What, can you think of examples of terms in a commercial agreement that have popped up in the due diligence process?
Yeah, I mean, certainly IP is always it's a red flag, right? It's something that everyone is going to pay attention to in diligence. Any kind of restrictive covenants, like ongoing obligations, whether it's non-solicits, non-competes, promises of most favored pricing.
Yeah.
Right. Those are always issues that come up because those are issues that continue to impact a acquiring company and in some cases impact how a company can grow or in which industries it can expand. So non-competes, right? Those are always challenging. And so, especially with smaller clients, we tend to want to thread the needle when especially a large company is saying, or large customer is saying, we need all of our vendors to do X, right? And so we try to massage the language to an area that we're going to be comfortable with. But if we're massaging it so that we're comfortable with it now, but in 5 years, it will still maintain a challenge, that's going to be an issue that creates, investor acquirer deal friction that certainly we would all want to avoid if possible.
Yeah. One of the other big ones that I see is rights to data. you may not be doing something with data today. And this is why, it's important to understand what data are you getting? What are you doing with it? Because if you're saying, okay, I'll only do these things, but then as the company's growing, you start to utilize new uses for data, you have to be certain that your contracts are providing for that use. And a lot of times, sometimes we'll see clients create super bespoke solutions for the risk in front of us today. Okay, we can silo this data off. We'll do this, we'll do that, which is great, but it's important to make sure that solution, you can build a process to implement that for the life of the contract. Because when these acquirers, the investors come, they will look and they will say, what are you doing with data? Let me see your top 5 customers. Let's make sure that you have the rights that you have. And so you want to make sure that you have all those ducks in a row, that yes, we have the rights that we need. And making sure you're working with counsel to get those rights, especially as kind of building in that roadmap, or providing flexibility for a roadmap for that use, I think can pay dividends. Well, so that's really great, helpful advice. So and now here we're getting to what everyone is here for. Taking these issues and putting them into practice is important. But Dan, can you please shed some light on when it comes to enterprise contracting and implementing a sales process? Like, it's great, these are just a bunch of lawyers talking, right? What do we do to actually get to sales in a realistic way? Because a lot of these customers, sometimes, if you have the pleasure of doing business with these whales, they'll tell you to pound sand. So what can companies do to implement strategies to kind of get deals done in a way that is manageable from a risk perspective today, and also isn't going to look weird to a buyer or investor down the road?
Yeah, I mean, obviously, it's a big question, right? And I think when you start moving to full scale enterprise sales and enterprise contracting, setting the stage is valuable, right? At this point, it may have been a months long sales cycle, and then all of a sudden you're bringing in new players into the mix, right? The lawyers, the procurement teams, right? And so at this point, you're still educating, right? You're still having to explain what it is that we're selling, and what is it that the customer is getting out of this, right? And so keeping that in the back of your mind, that this is still a sales process, is helpful and is worthwhile. And then again, it's when you bring in these new players, right, especially on the customer side, I think it's important to understand what the mandate is of the procurement team, right, and of the enterprise customers legal team, right? They're obviously there to help get the deal done, but they're also there to drive consistency within their organization. They have mandates to flow down specific terms to all of their customers, right? And they're certainly going to insist on their own forms. And so I think kind of identifying where there is friction in that process very early on can be really helpful, and knowing that issues in contracting are very rarely binary, right? And what I mean by that is, the vast majority of the time, what I may want out of a deal, and what Matt may want out of the deal may seem to conflict, but there is a resolution in the middle, right? We've talked about things like termination for convenience. Enterprise customers probably want termination for convenience. SaaS vendors probably don't, right? Is that a binary issue? Probably not, right? Because at the end of the day, what the SaaS vendor wants to do is they want to get paid for what they've priced the service at, whether it terminates early or not. What the customer probably wants is they want to be able to get out of a contract that isn't working, or contracting with a vendor that may pose reputational harm in the future, right? And maybe having to write a check for an early termination fee isn't the end of the world, right? And so there are a lot of issues like that where it seems that if you're in direct conflict, when you open the door to this type of collaboration and saying, here's what I need out of this deal, help me understand what you need out of this deal or out of this provision. All right, we can find a path forward. Can be incredibly helpful to pushing the deal forward in a timely way. I also think getting your walkaway items out on the table early is essential, right? Again, setting the stage, what's happening at the enterprise customers level. If they've brought procurement in the deal, it's frequent that they haven't even engaged legal yet. And procurement is operating off of a playbook. And if your walkaway item doesn't, if there's not a solution in the customer's playbook for your walkaway item, it's going to need to get approved at different levels within the organization. And that can frequently take a lot of time. So starting that process early, right? And trying to parallel path that process can avoid unnecessarily delaying the deal, and importantly, unnecessary cycles in contracting, right? And while we at KO, we're pride ourselves on, fast turnarounds when our customers need it. That's not always the case with enterprise customers and their internal processes. So each turn of the contract, when it goes back to the customer, that might take weeks. And that's going to impact the process. And then one last point, because I know I'm a bit on a soapbox here. I think utilizing your sales team throughout the contracting process is extremely valuable. The best sales professionals that I've ever worked with, the ones that help to shepherd deals forward, are ones who understand their contract, right? They understand why we as a company might be pushing for certain provisions. And not only can they speak to that, but they can speak to their business counterpart about why it makes business sense. That is always going to have much more of an impact than lawyer A telling lawyer B that this is what we need. So keeping your sales professionals involved, can really solve a lot of the friction that you see in these types of deals. So I'll pause there. Matt, Cory, I'm sure I've skipped over many key points.
No, I think that was a great overview. I'll give a +1 to just the value and importance of a skilled, experienced sales team or professional to shepherd the process through quicker, because I couldn't agree more that I think there's much more value through the course of a larger, more protracted negotiation to have less lawyer talk and more business folks talk about the solutions and the reasons and the whys, right? Like I know not all of my clients have a big sales team where they can spend time training and educating, but that might be the gold standard or an aspiration for some of our clients, or I know it is. But I do think it's exceptionally valuable to have the lawyer not viewed as, hey, run this call. It just feels less a little more tinny than fulsome. And I guess kind of a silly anecdote on that point is, like, when I open my email and I get an inbound request from a client saying, hey, can you review this contract? I mean, my answer is, of course I can. But I can't do it well without context and some understanding. And I feel like that's just maybe another data point on the level of sophistication of the business team, right? Like, or the salesperson. Give us a few sentences of background of what's going on, or if we're procuring, why do we need this to help us do our job? Because lawyers in a vacuum are not particularly effective or efficient professionals.
Yeah. Yeah. I think the last point that I just want to flag on that, and it's kind of back to the sales, the collaboration with sales, is there's a tendency to view legal and sales as being in tension. I think nothing can be further from the truth, right? Sales and legal, I think, can work so well together and collaboratively together, and are very much on the same team in terms of pushing the deal forward, getting the deal done. And I've worked with a number of clients where I've come in and done a training session to the sales team on, here's the contract and here's why, right? And it's been remarkably helpful to be able to kind of provide sales teams with the confidence to speak to the contract, which might seem like the purview of legal, but is really just a collection of key business terms. Cory, I'll pause there, let you jump in.
Yeah, no, that was that. I thought it was great. Yeah, nothing to add. So we have come to the Q&A portion of our webinar, and we've got some questions. So the first one, question to the group: how do you know when to engage a legal group to formulate a contract and take on the cost of legal versus going it on your own? Lawyers can be pricey. How does a small startup know when it makes sense to engage with legal? Wait for a big contract with value over the cost, funding of a certain size. Any rules of thumb for when to engage?
Michael, this is a wonderful question, right? And especially when we're working with startup clients, right? There is this tension. Lawyers are expensive. And what I would encourage you to do is, or the court encourage the group to do, is be upfront about those concerns, right? Because there are ways to kind of not necessarily do a half-assed job on the contract, but to be, allow legal to look at the form, a form that you've prepared, right? Or encourage legal to, engage based on templates that they've used previously. I will tell you that 9 times out of 10, it is cheaper. If you're working with a law firm that does these types of contracts on an ongoing basis, it can typically be cheaper to say, KO or law firm, do you have a template for something like this that we can rely upon, right? And maybe we're going to spend, an hour of time tailoring it to your business initially. But I do think even for your early sales, avoiding a common pitfall because you tried to do it on your own is going to save money in the long run, and potentially quite a bit of money. But I do think being upfront about the cost concerns and having that dialogue with your attorney is extremely valuable.
Right. And this feels very self-serving, but it is an investment, right? Whether it's $500 or $2,500 to help get that initial contract off the ground, it's an investment for that will be the foundation for the sales process for years, presumably, unless there are major changes in products or services. So I don't know if that helps kind of with the mental hurdle of, hey, this is costly. But I think that's a reality. And I know this is true for us. I think this is true for any good firm who's working with startups. their job should partially be to help you prioritize, right? Like we're dealing with folks essentially asking the same question Michael did regularly. And part of that answer is, well, let us help you prioritize. Like, what's going on? What do you need? What needs to be done in a month? What needs to be done in 6 months? What can wait 2 years? And that ties directly into budget and spend, and might be part of that conversation, um, as well as maybe stating the obvious, like finding a law firm like KO that's used to working with small startup clients and are used to these budget constraints and early stage issues. I do think one of your questions was, should I wait for a big contract? I definitely seen clients take that approach and sort of wait for something that's going to cover the cost. But I think that's a little bit at odds with what I said about it being an investment, and just kind of viewing it through that lens might be a little more accurate. I do think that in many cases you might be able to survive for some period of time responding to contracts provided by other parties. I see that probably more with vendors, your company's vendors providing you their contracts, and a good lawyer should be able to review most vendor contracts relatively inexpensively and help with issue lists and prioritizing risks and figuring out what to redline and what you're going to have to live with. But I think Dan's fundamentally right. Like, it's always worth having a conversation with KO or other law firms and explaining the situation and just seeing what is a reasonable approach.
Yeah, communication on the front end, certainly, because there's, the goal of contracts is not to alleviate all risk. Contracts are not without risk. There's even shared risk involved, and there's no one size fits all. So, perhaps it could be, a done is better than perfect, and our clients vary in what they're looking for. They may have specific risks that they're trying to solve, or, hey, my first customer, we need, kind of a vanilla off the SaaS or a vanilla professional services agreement that we can start providing, so you have the answers to those questions versus perhaps you get that first big customer contract, you initially engage counsel, and you have to respond in 2 days, and we don't know the business, or we haven't thought through, well, what rights do we need? It may not be putting that best foot forward for that customer, or alleviating those customers' concerns. And Matt, to your point, and again, that can all come in different flavors in terms of, not every contract is gonna account for everything. You can have something that's appropriate for a startup, and then it grows as your company grows and gets more sophisticated customers. You start adding perhaps an SLA or support exhibit, something to that, as you're getting customer questions. And the last point on that is, again, and then even keeping that eye towards M&A. If you don't have the agreements in place, oftentimes, if you're fortunate enough to get to the M&A level or the investment financing, et cetera, you may have to go back and paper over certain things and clean it up, and that expense just comes later. And so I think there's no one size fits all, but finding counsel, communicating with counsel, and finding counsel that can kind of work with what your business needs today versus what your business needs in 6 months and a year can always be a great investment. So we've reached our time for the day. Thanks, Matt, Dan. Thanks, everyone in the audience, for participating. I thought this was a really great discussion. And please, if you have any questions, or your question wasn't answered and you'd like to follow up with us directly, we have our contact information up on the screen. And so we're happy to chat. And we look forward to doing this again in the future.
Thanks all. Thanks, Cory.
Thanks, Cory.
Everyone.
Bye-bye.